The market capitalization of the coin is used to summarize all that is taught in this video. I would also like to remind you to give my channel a like and subscribe to it so that you can stay up to date on future XRP news as well as other cryptocurrency news in general. Proceed to take a look at this countdown in the SEC case involving Ripple. On October 24th, the final date will rapidly approach. On the other hand, before we go any further, there is a brand new cryptocurrency airdrop that is currently taking place on Telegram and is set to start at any moment. I would ask that you make sure that you take part in this airdrop. Within the video's description is where you will find the link. Make sure you don't miss out on this opportunity. In the meantime, let's proceed with our video. Ripple has hit a key milestone in the ongoing legal struggle that it is engaged in with the Securities and Exchange Commission (SEC). After the United States Court of Appeals for the Second Circuit issued a procedural warning to Ripple, Chris Larsen, one of the co-founders of Ripple, has been responsible for presenting a crucial document to the court as the time creeps near. This comes as the deadline is getting closer. The submission that you have made is now available. In the ongoing dispute between Ripple and the SEC, recent developments have occurred. On October 22nd, the United States Second Circuit Court of Appeals informed Ripple that it was obliged to submit Form C as part of its cross-appeal against the Securities and Exchange Commission. This was done in order to comply with the requirements of the court. Christopher Larsen swiftly provided the court with a notice of appearance in response to the court's request for additional information. Due to the fact that the deadline of October 24th has already passed, this action is being performed in an effort to speed up the process. His presence was the statement that was made about the news on the Good Morning Tog, close to the end of Form C, by the 24th of October. Ripple is obliged to submit Form C in order to lodge its cross-appeal against the Securities and Exchange Commission. In the event that the form is not submitted within the given time, Ripple stands the risk of being deprived of the right to present its oral defense. Eshwar El-Durodi, the chief legal officer of Ripple, has made it abundantly clear that this filing will not have any impact whatsoever on the judgment that the court will reach regarding the question of whether or not XRP would be considered a security. Despite the fact that the United States government has not changed its position on the conclusion that XRP is not a security, they have changed their viewpoint. A further point that El-Durodi brought up was that it is quite unlikely that the DSCCC will be able to achieve the result that it has envisioned for this particular instance. The community of people who use XRP is waiting with bated breath for the verdict in this case because of the potential outcomes of the case and the impact it will have on the cryptocurrency. In the event that Ripple emerges triumphant, it is believed that the price of XRP will enjoy a significant boost, maybe breaking through to new highs. There are some people who believe that the price of XRP might eventually reach as high as $17. This is a speculation that some people feel will happen. To emphasize that the cross-appeal is designed to reverse the penalties that have been imposed by the Securities and Exchange Commission, Ripple's officials argue that they have not committed any procedural errors and make it clear that they have not committed any errors in the process. Taking everything into account, the recent actions made by Ripple constitute a significant milestone in the ongoing legal battle that is taking place. Should the lawsuit be decided in favor of Ripple, there is a possibility that the value of XRP would enjoy a considerable increase. Mark Fagel, a former attorney for the Securities and Exchange Commission, has found himself in the spotlight in order to provide insightful commentary regarding the ongoing legal battle that is taking place between Ripple and the CC. Within the context of the litigation that concerns the Securities and Exchange Commission in the case of Ripple, the United States Court of Appeals for the Second Circuit has just recently issued an acknowledgement and notice of appearance default notice. Because of this statement, the XRP community has been engaged in a significant amount of conversation, with many individuals reading it as a warning to the SEC regarding its compliance in the proceedings. This community has been engaged in a big amount of conversation. We have no doubt that you are eager to obtain additional knowledge regarding the implications of this for the regulation of cryptocurrencies in the years to come. We are confident that you are already interested in this. During the meeting that took place behind the notice, Fagel made it quite apparent that the notice is addressed directly at Chris Larsen, who is one of the appellees in this lawsuit and is also a co-founder of Ripple. Continue reading because you will acquire some comprehension of this. These actions are not the focus of the notice that is being issued. He went on to explain that the legal team that was defending Larsen had failed to file the required notice of presence by the date of October 18th, which resulted in the court issuing a 14-day extension for compliance. In his speech, Fagel brought to everyone's attention the serious consequences that could result from this error. In the event that Larsen's legal team fails to provide the necessary documents by the deadline of November 5th, they run the risk of losing the opportunity to present oral arguments, which might potentially cause Larsen's position in the case to suffer significant damage. In addition to the ramifications for Chris Larsen's legal strategy and the implications for his legal approach, the notification raises a number of important challenges. In the event that they fail the amended deadline on November 5th, it is possible that his legal team will be unable to effectively advocate for him. Because of this, Larsen will have less of an impact on the case from this point forward. When dealing with high-stakes litigation, such as the SEC vs. Ripple case, which is being closely observed, it is of the utmost importance to comply to the rules of procedure. In this particular situation, the significance of doing so is demonstrated. Ripple's chief legal officer, Stuart Alderati, has confirmed that the corporation would give its pre-argument by the 25th of October in the year 2024. This information pertains to Ripple's forthcoming behaviors throughout this time period. It is anticipated that this filing will present a challenge to the conclusion that Judge Torres reached regarding the institutional sales of XRP. Following that, a timetable for the submission of appeal papers will be devised, and the Securities and Exchange Commission (SEC) will most likely be granted up to 90 days to react. His scenario has the potential to extend the legal battle until the middle of the year 2025. As Ripple continues to engage in a legal battle with the Securities and Exchange Commission (SEC), the business is taking strong action. Chris Larsen, who was one of the co-founders of the company, has been responsible for submitting a significant document to the court at the precise moment when the deadline for a vital file is drawing close. Following a warning issued by the Second Circuit Court of Appeals addressing procedural issues about Ripple's case, this stage in the process has been taken. Are you able to provide an update on the most recent incidents that have occurred in the SEC case? A reminder was sent to Ripple by the Second Circuit Court of Appeals on October 22nd regarding the relevance of completing its Form C submission for the purpose of initiating a cross-appeal against the Securities and Exchange Commission. The swift action that Larsen took consisted of presenting an urgent motion to speed up this process in advance of the deadline that was approaching. The deadline for Form C is approaching. Will Ripple be able to meet it? Ripple is required to submit the Form C document by the 24th of October in order for the company to maintain its right to contest the judgments that have been made by the SEC. Should Ripple fail to fulfill this deadline, it is possible that the company may lose the ability to maintain its opportunity to present an oral defense in court. It should be emphasized that the submission of Form C will not result in a change to the current classification of XRP as a non-security instrument. Due to the fact that the ruling that has already been rendered regarding XRP is still enforceable under national law, this classification has been in effect for the time being. He made the point that it is challenging for the Securities and Exchange Commission to accomplish the goals that it had set for itself at this level. What sort of implications can this possibly have for the future of XRP? A careful eye is being kept on the development of the case by the communities that are located in close proximity to XRP. In the event that Form C is not submitted by the deadline of October 24th, it is possible that the opportunity to present a defense will be lost. On the basis of the laws that are currently in effect, Ripple asserts that XRP is regarded as a non-security financial instrument. It is possible that the outcome of the case will have a substantial impact on the value of XRP on the market after it is decided. The preventative actions that Ripple has taken coincide with a critical turning point in the legal path that the business is planning to take. It should be noted that the material that has been supplied is not intended to serve as business advice. In the event that any investments are made on the basis of the information that is provided on this page, there is no responsibility for those investments. Prior to making any choice on investments, we strongly recommend performing independent research and talking with a professional who is educated in the field.